Transporting goods over long distances often involves multiple companies, contracts, and subcontracts as goods travel by ships, trains, trucks, and planes. But untangling what law governs all of these agreements and which parties the law binds can become complicated. In Norfolk Southern Railway Company versus Kirby, the Supreme Court considered what law governed the amount of damages a cargo owner could recover after a train carrying his goods derailed and he incurred major losses. James Kirby, an Australian manufacturer, hired International Cargo Control, or ICC, an intermediary shipping company, to arrange the delivery of goods being shipped from Australia to Alabama. ICC issued Kirby a contract setting the shipping terms, known as a bill of lading. The bill used the default liability limitation from the Carriage of Goods by Sea Act, which limited ICC's liability to $500 for each package. The bill also included a Himalaya Clause, which extended that $500 limit of liability to ICC's agents or independent contractors. This was far less than Kirby's packages were worth. At the time the bill was issued, the actual liability per package was calculated as exceeding $17,000. ICC outsourced the transportation of Kirby's goods to shipping carrier Hamburg Süd. Hamburg issued its own bill of lading to ICC, which also invoked the $500 liability limitation and included a Himalaya Clause. After shipping the goods to a Savannah, Georgia port, Hamburg hired Norfolk Southern Railway Company to transport Kirby's goods to Alabama by train. Unfortunately, the train carrying Kirby's goods derailed, resulting in $1.5 million in damages. Kirby sued Norfolk, alleging tort and contract claims to recover the full amount of damages. The district court granted Norfolk partial summary judgment, ruling that the Himalaya clauses in the bills of lading limited Norfolk's liability to $500 per package. The court certified its decision for interlocutory review, and the 11th Circuit reversed, holding that Norfolk wasn't covered by either bill's Himalaya clause. The Supreme Court granted cert.